Thank you for joining us today. On behalf of LegalEASE, I'm thrilled to welcome you to our estate planning webinar presented by the esteemed Kern Singh of Singh Law Firm. Estate planning isn't just about preparing for the future, it's about protecting what matters most, your family, your legacy, and your peace of mind. Whether you're just starting to think about your estate or looking to refine an existing plan, today's session will empower you with the knowledge and tools to make informed decisions. Our presenter, Kern Singh, brings a wealth of experience and insight to this topic. His practical guidance and deep understanding of estate law will help demystify the process and highlight the strategies that can make a real difference. So grab a pen, settle in, and get ready to take control of your future. Let's dive into the essentials of estate planning and discover how you can build a plan that truly reflects your values and goals. An educational webinar for a nationwide audience. Kern, would you like to introduce yourself?
Thank you so much, Charlie, and to the entire LegalEASE team. I really appreciate the opportunity here, and welcome to everyone joining us here today. My name is Kern Singh. I'm an attorney, founding partner of the Singh Law Firm. We're based out of here in California, and today it's my honor and privilege to walk you through the tidbits of estate planning, the ins and outs. Why do we need it? What is this all about? What are the documents? We'll get into that, go through some Q&As, but it is my absolute honor to be here with you today. When we talk about estate planning in general is this term we hear. It's a term of art, and it's a product of documents, a collective of documents. And the documents that make up your estate plan are typically four documents. They're a living trust, wills, financial powers of attorney, and healthcare directives. And some of the big components here is your estate plan is needed because it helps us take care of things throughout our life while we're alive, as well as when we pass, to make sure certain things are taken care of and keeping the courts out of this whole process and letting people we've nominate step in to take care of our affairs when either we're alive and incapable of doing so, or we have passed and we need these individuals to step in. So the whole premise here is we've got some legal contractual documents in place. They're here to help us and keep the courts out and make this process simpler for our families and keep the headache and away from our families should something happen to us as individuals and as a married couple. Next slide, please. So when we talked about estate planning, like I mentioned earlier, it's made up of a living trust, wills, financial powers of attorney, and healthcare directives. And the goals here are to accomplish these documents, but in order to accomplish them, you're going to have to dive into the documents and understand what each document does at different stages of our lives, who to choose as key players, and we'll get into all of that here in a moment. That's the purpose of today, is to help you all get to the end zone of having your estate plans established and knowing how to select these individuals. Now, some common misconceptions of estate planning is that, well, I am not Warren Buffett, I'm not Bill Gates, I'm not Mark Zuckerberg, so I don't think I need to have an estate plan. I don't need this revocable trust. People think these terms are too fancy for them, but at the end of the day, the bottom line is this. Everybody out there who is living and breathing in the United States has an estate, down to the person who does not own any real estate, who's living on the streets, to Mark Zuckerberg or Bill Gates. They have an estate. It's all your belongings, the things that you've worked hard for your entire lives, whatever that is. These are your assets, and you have every right to decide and determine how those assets go to the next of kin, people who you want to choose as beneficiaries. Never leave it to the state. So a common misconception is, I don't need to establish my estate plan because I'm not wealthy. That has nothing to do with it. Okay. Number two is, well, you know what? I'm going to go ahead and just add my children's names to my bank accounts and real estate, and that's going to solve the problem. I don't need to set up my estate plan. Well, that's an incorrect idea. It can create huge negative consequences for you and your family. One could be gift tax issues, exposing your own assets by adding your children's names to the title of your assets, to their liabilities and creditors. Think of their divorces, their litigation issues now coming after your assets when you just innocently added their names to the title of these assets. So again, misconceptions: don't take things into your own hands. Don't do things just because your friends have talked about them or you read it in a magazine. Go hire an attorney who is experienced in estate planning, who understands this, and get the advice that you need for your family. Do not take this into your own hands. And why is this important for everyone? Well, we are born one day and we pass one day, and it is our absolute responsibility to make sure that should we pass, we have things arranged in order. Everything is organized for our family. You never want to leave them in a situation where you're gone and now they're exposed to probate. They don't know where your bank accounts are. Maybe you had, some businesses and they don't know where key players are, key informations are. You need to leave some sort of a guide, and your estate planning provides the blueprint for all of this because it allows you in a change of mindset to get organized. So but our objective today is to get you on the most basics of foundations. What's an estate plan? What are the documents? How do I think about it? Who do I choose? If I have young kids, what do I do with the young children? Do I expose my estate to my children, to any guardianship, foster care type problems that arise? No, we don't want that to happen. So that's what we're going to do today. Next slide. So as I mentioned earlier, these are your core estate planning documents. And typically, when we go through these, we're going to go through these one by one and explain to you what they all do. And then also kind of eliminate any preconceived notions of why one document shouldn't just do everything for everybody. So without further ado, we talked about your estate plan being made up of a living trust, wills, financial powers, and healthcare directives. Now, if we go to the next slide, we'll talk about the last will and testament. Okay, so now when you have an entire estate plan, which includes a revocable trust and a will, the will within the estate plan itself is not the will that you perceive in your mind that's going to be dividing up your assets and taking care of everything top to bottom. In fact, your revocable trust takes care of all of that. So when you have an estate plan, the purpose of your will, and sometimes we use the terms interchangeably, like last will and testament, but at the end of the day, your will, when you have a living trust, is typically deemed a pour over will. And the purpose of a will, when you have a revocable trust, is to define whether you are married or not. So marital status, and identify if you're married who your spouse is, identify if you have children, identify their names and date of births. Then you will be identifying who your executors are of the estate. And you will also nominate, if you have children under the age of 18, guardians for those minor children. Okay. For all other purposes, the will then dictate, should I pass, the assets I leave behind, the terms of my revocable trust will dictate what happens to those assets. So in fact, everything we think our will should do as far as distribution of our assets is stripped away from the will. Those powers are shifted over to the revocable trust. So then the will is identifying who you're married to, if you're married, children, executors, and guardians. That's the purpose of the will. Now, guardianship within a will is very important for families out there who have children under the age of 18. It is your job, your duty as a parent, to elect and nominate guardians for these minor kids. These children, while they're under the age of 18, have no legal rights to make decisions for themselves. They cannot apply for a passport, file their own income taxes. Wherever a legal authority signature is required on behalf of those children can't sign. It has to be their parents. Now, if their parents are gone, who are their actual biological guardians, those parents are gone. And if you have not nominated actual guardians for these children, then you're subjecting your children to the foster care system in the United States, and you don't want that to happen. So take the step today to nominate guardians for those kids. Guardians' jobs for children under the age of 18 last until they get to the age of 18, because as soon as kids turn 18, they have that bundle of sticks, those rights that the government gives any other adult. They can take care of these things on their own. They don't need someone to take care of them. But while they're under the age of 18, the characteristics you want to look for in a guardian are the following. You want to choose people who are like-minded as you, have the same family values as you, have the same family environment, household environment as you guys do. They are great with children. Your children know who these individuals are. Just because you feel comfortable with a select, 3 or 4 guardians because you feel so comfortable with them, but maybe your children do not know who they are. Maybe your children do not have a relationship with them. Now imagine you have passed and you on paper have said, I wanted Jim to be the guardian of my minor kid, but your kid has never met Jim, or your kid has had limited with Jim. Well, the problem here is that you force your child into a home where that kid does not know this individual just because you felt comfortable. So you want to make sure that you're looking even deeper beyond, is this person able to take care of my kids? Do they also have a relationship? And maybe they don't have a relationship today, but that is something that you should be looking into building as time goes by. That is our job. Our duty is to build that tribe to be able to handle these things for us when we are no more, to make sure that the people we leave behind are taken care of mentally, physically, and financially. So guardianship, very important part of your will, but as far as distribution of assets go, it does not happen out of the will. It is going to happen out of your revocable trust. Next slide. Now, a durable power of attorney is a document, and I like to also call it a financial power of attorney. And I like to put that word financial power of attorney in place because, in my mind, when I talk about estate planning, there's 2 types of powers of attorney within your estate plan. One is the financial power of attorney. Usually, a lot of people also refer to it as a durable power of attorney. There's also a healthcare power of attorney, or a durable healthcare proxy, or a healthcare directive. That's a separate document, but that's a power of attorney for health. Now, your durable power of attorney or your financial power of attorney comes into play should you become incapacitated. Now, what does this mean? This means that I'm still alive. I have not passed away. I'm still alive. And now I'm unable to legally make decisions for myself due to some mental incapacity. 2 doctors have stated I am mentally unsound. Now I'm incapable of making legal decisions on my own. At this juncture, if I have a financial power of attorney in place, this document would kick power over to people I've selected. So if I'm married, my spouse, and then a couple of other individuals as backups. So should I become incapacitated in that specific order, they would step in and take care of my financial affairs while I am incapable. Now, if I don't have this financial power of attorney in place, the downside is this: my spouse, my adult children, my mother, my father, my brother, my sister. I don't care who they are, how close they are to you. Nobody, your spouse, nobody has the ability to sign your name on any documents. They are going to have to go to court and get a conservatorship from the judge so that they can now legally make decisions on your behalf. Now, in order to get a conservatorship, that takes several months, if not longer, and can cost tens of thousands of dollars in attorney's fees. Then annually, while that conservatorship is in place, you're going to have to go annually to go do accounting and other motions, and that could take time, and also, again, attorney's fees involved. So we are trying to avoid the court process should you become incapacitated. And in order to do that, you'll have your financial power of attorney in place. So this contractual document that you signed while you're sound of mind, giving power to persons A, B, and C, they would then be able to step into your shoes should you be deemed incapacitated to take care of your financial affairs without the court intervening. Again, making the process seamless, making it less stressful for everybody. Remember, my spouse does not have any legal authority to make any decisions on my behalf. And this is a misconception that people also have. Think about filing income tax returns. Think about signing your name on the deed of a home. Think about filing for your passport. Anything, anywhere, some third party's asking for your signature, you are the only person allowed to sign. No one else can sign unless they have some legal power to do so. And that is this document, the financial power of attorney. We hope we never have to use this document. It's there in place in our little toolkit that we have, should we need it in the future. Now, should we pass The financial power of attorney essentially passes with us. It dies with us. It only covers us while we're alive and incapacitated. Now, if we pass, the living trust would be able to come into play and help with taking care of the financial affairs now that we're gone, and we'll get into that in a moment. Next slide. The healthcare proxy, the medical power of attorney, I refer to it as a healthcare directive. This is very similar to your financial power of attorney. It's a healthcare power of attorney. Again, you select people of your choice to make healthcare decisions for you. Should you now be incapable of making healthcare decisions for yourself due to a mental incapacity, two doctors have dictated or deemed you incapacitated, no one, not even your spouse, mother, father, adult children, brothers, sisters, have the ability to communicate with the hospitals to make a medical decision on your behalf should you not be able to, and the doctors are not going to do something out of necessity to save your life. So in that scenario, if I don't have a healthcare power of attorney in place, my family would have to go to court and get a healthcare conservatorship over me in order to make these decisions. Remember, the logic here is this. If I, Kern, am in the hospital and I'm incapable of making a decision on my behalf, and my spouse is there at the hospital, and let's say behind closed doors, my wife and I are probably going to go through a divorce, hypothetically speaking. The doctor who's attending to me at that moment does not know my relationship with my spouse. And if they want to say, hey, spouse, tell us what to do, and the spouse wants to off me in that situation, well, there's a problem there for the doctors, right? They can't just go off of and assume what the relationship is like. Their job is to focus in on the medicine. They need a legal document showing that this spouse has power over the person who's incapacitated to make a decision in order to alleviate their liability. So that's where that document would come into place. Now, if that document is not there, in order to protect the doctor's liability, they're going to tell my spouse to go to court and get a healthcare conservatorship over me. That way, the judges, the court system can do all their due diligence to make sure that there's no weird problems between the incapacitated individual and the person trying to get power over them. That's their job, not the doctor. So logically, when you walk through the process, you see the kind of the complexities and the legalities behind it. But this healthcare power of attorney allows us to provide some wishes as to what we'd want under certain medical decisions, giving power to people to make those decisions for us, as opposed to them collectively making a decision through the court process of a conservatorship. Next slide, please. And so the last slide was a healthcare proxy, and now we're getting into the living will and advance directive. In essence, more often than not, when we establish an estate plan for a client, our one document, which is called a healthcare directive, will include the healthcare proxy, which is assigning someone to make healthcare decisions for you. And then the living will advance care directive is synonymous. Again, all those components and legalities are in that singular document. And that is where essentially lay out your decision, life support, organ donation, cremation versus burial. Remember, more often than not, we don't have these conversations with our spouses, our kids, etc. It's just kind of one of those subjects that people don't like to have conversations on. And when something does happen, there's a little bit of confusion as to maybe what you would have wanted. This way, you just take that burden off of everyone in a time of stress as to what you would have wanted. Next slide. Now we get into the most robust document out of this whole plan. So going back to the drawing board, just to kind of get some baseline here and press pause for a moment, is that your estate plan will include a living trust, wills, financial powers, and a healthcare directive. Your financial power of attorney and healthcare directives come into play should you be incapacitated and decisions for healthcare or finance need to be made. The benefit here is we avoid conservator over the individual for your health and finance. The purpose of the will is to identify key players, marital status, children, who your executors are, and who guardians are for your minor children, but your will does not divide up your estate and distribute it. That all happens out of your revocable trust. So your revocable trust, if you didn't have a trust, and let's say you just did a will by itself, and your will did state, I'm married, I want my assets to go to my wife or husband, and if I'm not married, I have these kids and I want my assets to go to these will do, unless you're happy, will by itself will not avoid the probate process. Let's say that again. Your will not avoid the probate process. The probate process is precisely what we are trying to avoid by establishing your estate plan. Probate processes, and specifically in California and other states in general, can take a significant amount of time. In California, your estate will go through probate if you own any real estate or you have any bank accounts. So if you have real estate or bank accounts, and God forbid you were to pass without a revocable trust, maybe a will or no will, it doesn't matter, your estate ends up in the probate process. The probate process can take 2 years or longer. There are court costs involved, attorney's fees. Typical fees in the probate process can be anywhere from 4 to 8% of the fair market value of the estate being probated. In California, you go to the big metropolitan cities, if you own a house and you have a couple of bank accounts, most of the professionals out here will have at least $1 million to $2 million estate. Now, for that estate to be probated, it could be anywhere from $40,000 to $80,000, if not more. And the problem here is that if you don't have the cash and the bulk of your estate's tied up in hard assets, those assets will have to be sold in order to pay for these fees. So there's the probate fees we're talking about, the time that's involved, the headache for the family going back to court constantly and having to relive you failing, not establishing your estate plan and going through the headaches and paperwork and the stress of all the probate process, and then the potential for litigation. Our court systems are wrought with fraud and whatnot when it comes to these types of things, because people come out of the woodworks and say they're your long lost sibling or child. We have cases like Prince, the performer, James Gandolfini from Sopranos. They all passed without trust and their estates went through probate, and people did come out of the woodworks, and now they're having to defend it and more money is being wasted. So probate's the process that we're trying to avoid. Just like the conservatorship and the healthcare directives help us avoid conservatorships, we're trying to avoid the probate process. In order to avoid the probate process, you have your revocable trust set up. Now, if you have your trust set up, you're going to have all these probate triggering assets transferred into this trust. So think the title of your home. You establish your revocable trust. Your title of your home should be changed at the county level to reflect that it's in the name of the trust. Bank accounts that would trigger probate court should be retitled at the financial institutions they're held at in the name of your trust. This way, your trust is like a bucket, and I kind of like to use the analogy, it's like your suitcase. So imagine I'm going to Hawaii tomorrow and I'm going to throw on my bed my suitcase today. I'm going to put in my suitcase my board shorts, my sunscreen, and my flip-flops. And I'm going to lock up my suitcase, go to Hawaii, and when I get to Hawaii, I open up my suitcase and my items are actually in my suitcase. But if you don't put your items in your suitcase and you just simply wrote on a yellow pad, board shorts, sunscreen, and flip-flops, and put that list into your suitcase, and I went to Hawaii, I open up my suitcase in Hawaii, all I'm going to have is that list. It's useless. So you actually have to physically transfer these assets into your suitcase, your trust, change the title of them. And that's something your attorneys should all either help you with, whether it's real estate, and or give you guidance on how to do specific, explicit instructions on how to have that handled, because that is a very big step. So funding your trust, transferring your assets into the trust, and then while you're alive, you are the trustee. Nothing changes on the way you operate your bank accounts, your ownership, your rights do not change. You have now just created a clear cloak to protect your assets. And then you, by contract, which is your trust, and then your trust lays out what happens should you pass. Should I pass today, I want trustee number one to step in and manage the assets for any beneficiaries that are there. Now, if I have beneficiaries which are my children and my children are young, I don't want my children to inherit the money until they get to a certain age. So you can select an age of inheritance. I'll use myself as an example. I have 2 children, and my trust says that when my wife and I are both no more, then our trustee number one steps in, manages the money for our children until our children get to the age of 25. Once our kids get to age 25, that's when they inherit their share of the estate. Now, before the age of 25, should my kids need money and my wife and I have passed, our trustee must spend the money on our children for our children's health, education, maintenance, and security. So the money is there for the children. It's just controlled and distributed by the trustee for HEMS, health, education, maintenance, and security, until the kids get to the age we've defined them to get to, that age of inheritance. And then when they get to that age, they would inherit it. Now, if your children have drug problems, alcohol problems, or there's other things that are causing issues and concern in their behavioral aspects of their lives, we can put and look into putting restrictions and in what I call incentivizing provisions in your trust to try to potentially correct these bad behaviors. But keeping things simple, the purpose of your trust is to avoid probate. You're going to select people called trustees who will step into your shoes to manage your assets for the children or your beneficiaries. So again, the purpose of your trust is to avoid probate, and a will by itself does not avoid probate. So now, as you can see, probate's the bad guy. In order to get rid of probate, you need the trust. We got the trust involved. We got the trust properly funded with our assets. It's gotten rid of probate. We have the will off to the side. The will isn't dividing up our estate. The will is not avoiding probate because the trust took care of all of that. The purpose of the will is identifying key players, pointing back to the trust. The trust is now our most robust document out of this whole, conglomerate of documents that we've established. Okay. Now I want to, and then we'll go to the next slide. Sorry. And before we go into the other key considerations, what I wanted to discuss briefly here was going to be how to select people in these various capacities we're nominating them for, right? Because you're establishing documents, you're establishing the trust, the wills, the financial powers, and the healthcare directives, but each of these documents are going to have key players you're nominating to step into your shoes to take care of actions for you. So in your revocable trust, you're going to have people called successor trustees. Successor trustees only step into your shoes once you are gone. If you're an individual and if you are married, both spouses are no more. That's when your successor trustee comes in to manage the assets and distribute them. What should you look for in a trustee? Well, the first 5 letters of trustee are TRUST. You got to trust these people. Number one. You're going to select people who are in the US to be your trustees. They're good with money. They're like-minded as you. They're, conservative if that's important to you. Your children have a relationship with these individuals as well. They're trustworthy, like I mentioned earlier. And then you're going to select people who have the same mindset with money as you do as well. And then with that, as time goes on, you have the ability to amend the trustee section. You have the ability to amend the other key player sections as well. And we'll get into that in a second. But trustees, people who are good with money, they're settled, they're not struggling financially, there's no big things going on in their lives, which does not allow them to have time to do the work that you need them to do for your family. And again, they have a relationship with your children because that's important here as well. When you're looking at your wills, you're nominating people called guardians if you have children under the age of 18. And guardians are people who take care of those kids. You want to look for characteristics in these people that they have the same household environment as yours, the same family values. If religious type of stuff is important for you in raising your children, you want to look for those qualities in them. If you have only daughters, maybe don't select a family that has only boys in their home because your girls are going to go into a house full of boys and vice versa. So if those things are important, look at that. Be logical. Your kids should have a relationship, should know the guardians. These kids are going to go live in that household, so they need to feel comfortable. You also don't want to disrupt your children's lives. They're going to school in a certain location. Maybe it might be worth keeping that continuity going for the children, staying in the same locality. So you want to really weigh those considerations here when selecting a guardian. Selecting a healthcare agent, again, these people need to be readily available to make a healthcare decision for you. We don't want to be waiting for them because they're coming from overseas or they don't have the ability to ever come to the US. So select people in the United States. They have the ability to go physically make these medical decisions for you. They're sound of mind making these decisions. They're not highly overly emotional. They're logical. Again, we want decision makers. We don't want emotional decision makers. We want decision makers. Think logically when you're going through that. And then obviously you can always ask your attorneys for other advice that they have, but that's what I look for. And then as far as these nominees go, as time goes on, our relationships with all these individuals change, our confidence level in them changes. We see things going on in their lives that we don't think is a good fit for the way we're leading our lives, values, whatever. So whenever you feel any uncomfortability, amend your document so that you have a fresh list of individuals you want to nominate to make these decisions for your family. Next slide.
Okay, Karen, so we're going to get into the Q&A, common questions and answers, and I'll just ask you the question and allow you to give us some advice.
Sounds great.
Do I need an estate plan if I don't own a lot of assets?
The answer is yes. I'll give you a case study here, an example. This was about 10 years ago, and it's happened multiple times after, but I've had, probably like 12 years ago. We had a single mother, just started working very young, had a child about 5 years old, and mom was a professional working. She did not have a significant amount of assets. She didn't own any real estate. Her bank account, I think, had maybe $25,000 in it, not enough to trigger probate per se. So no necessary probate in this estate, but mom did have a life insurance policy that she had through her employer, and she had a small life insurance policy that she had purchased, I believe, from State Farm, if I'm not wrong. And because the child was a minor, she could not, I should say, select the minor as a beneficiary on the life insurance policies, because if she did and something happened to her, the life insurance company would not give that 5-year-old any money from the life insurance proceeds until the child got to the age of 18. The problem there is that the purpose of life insurance was to provide money today should something happen to mom, and now the child would have to wait 13 years in order to get the money. That's useless. The child needs the money today to carry on a certain type of lifestyle. So what was recommended to mom was establish the estate plan. Now, even though you don't have a probate estate, you will absolutely grow into it. But because you have this life insurance policy, you have your trust set up, you will make the primary beneficiary of your life insurance policy your revocable trust, not your child. This way, should something happen to you, the life insurance company will cut that $1 million life insurance proceed check to your trust. Your trustee would be able to deposit it the next day into your checking account, which was held in your trust, and use the money for your 5-year-old right away. So exactly what you wanted to happen with that life insurance policy is accomplished by having that trust set up. And in that scenario, it was imperative to have an estate plan established, even though this mother did not have a lot of assets. That's one example of many that I can go over.
Wow, that's a great example. Thank you for that.
You're welcome.
What's the difference between a will and a trust?
Beautiful. So, we've heard in movies, we've read in books, we've seen soap operas, people pass and everyone panics and says, where's the will? Find the will. Let's read the will. What does the will say? And let's follow the will. Well, at a baseline fundamental level, a will does give guidance as to what you want, but a will does not avoid the legal pitfall of probate. It does not avoid probate. The will identifies, like I mentioned earlier, who your children are, who you're married to, who your guardians are for minor children. And then the will has an explicit provision that says, for all other purposes, distribution of my assets, please refer to the terms of my trust. So that's really all your will is doing. So now everything that we perceived our will to do beyond just that is actually being stripped away and held in the revocable trust platform, along with a multitude of other provisions. But now the trust is going to be dividing up our estate. The trust will be able to put restrictions on how and when our beneficiaries inherit our assets. Our trust will be able to help us avoid probate. Our trust will help us avoid any litigation that occurred after I pass, and our beneficiaries are beefing about how our estate is to be distributed. We're not going to have a court interference in this juncture because we contractually decided what's going to happen. So the difference between a will and a trust is a will doesn't avoid probate, a trust does. The trust is more robust. The trust has all the bells and whistles that we need in order to protect our family.
Okay. What happens if I die without a will?
If you die with a will or without a will, your estate, number one, is going to go through probate. If you die without a will, that means you have not dictated how you want your assets distributed. And typically, each state will have what we call the laws of intestate succession. What happens when you die intestate, without a will, without any direction? And in California, intestate laws state that if I pass, my assets naturally would go to my spouse. If my spouse isn't there equally to my children, if one of my child or my children aren't there, then the asset should be split amongst my grandkids. If I have no grandkids and no more descendants below us, then the assets should be split amongst mine and my spouse's parents and go down this kind of elective tree downward. So if you pass without a will, we go through probate and your assets will go according to intestate succession. So we're going to have the pitfalls of probate, length, costs, etc., exposure to litigation, exposure to people coming out of the woodworks, and then intestate succession laws. So we don't want to go down that route. It's just something that we do not want to leave our family having to deal with.
Understood. Who should I choose as my power of attorney? And Kern, you thoroughly explained this earlier, making sure that you're choosing the right people, but feel free to summarize.
Yeah, 100%. Your power of attorney agent, we call that your attorney in fact is actually the legal term of art. Your attorney in fact, not me, the lawyer, but the power of attorney agent you're nominating is actually more often than not going to be the same person you select as your trustee. It's a financial job. You're choosing your successor trustee to manage your affairs when you've passed away. You have no control at that point. Your successor trustees should probably also be the ones taking care of your affairs should you be alive and incapable of making those financial decisions. It's the same financial decisions they're making when you pass while you're alive and incapable. So naturally, it'll be the same person. You got to trust them. They're good with money. They're settled financially. They're not struggling, financially, and they can make logical financial decisions.
Thank you. Can I create these documents myself or do I need a lawyer?
There's LegalZoom out there. You can do those documents yourself. Should you do them yourself is the better question. The answer is no, right? You should not. You don't. Each state has different rules. And not only does each state have different rules, there's different things that you need to do depending on different assets you have. There's the issues of my children, the issues of the people we're selecting. This is something that you definitely do not want to take on your own because the effects of this, the way these documents are executed and handled and the powers that come to play usually happen when you are not able to answer for yourself, to explain why you did something a certain way. Think about being incapacitated. Think about passing away. No one can question you at that point as to what your intentions were. And if you did something incorrect while doing it on your own, that's the problem you leave. Is again, you're leaving the problem for your family. And I know LegalZoom can do documents, but you're getting charged a ton of money on LegalZoom, and you could have spent a little bit more and hired a professional to get the job done. I've seen it too often where clients have done this work on their own. And in fact, I've seen clients try to do it on ChatGPT. And they do it so poorly. They've used laws from different states or the way it was done. They haven't funded their trust. They didn't get the document signed a certain way, would follow all the formalities. And this is not where you want to save a few dollars. You want to get this done yourself. I kind of explain it this way. Would you do surgery yourself? The answer is no.
Right. Scary.
Oh, 100%.
How often should I update my estate plan?
Excellent question, Charlie. Now, you typically we tell our clients you want to update your estate plan when there is a life-changing event in your life. Life-changing events are people have passed away, whether it's you, your spouse, people you've nominated, children. So people have passed away. You want to change the order of your nominees. Think about the people you've nominated, your successor trustees, your guardians, your healthcare agents. You want to change the way things are distributed in your trust. Originally, you went equally amongst your kids, but maybe one kid is doing well and the other children are not doing that well financially. You want to give more to the ones that are struggling and less to the other, or kids are behaving poorly. So there's a change of distribution. Maybe there's a divorce between husband and wife. Your kids are adults now and you feel comfortable and confident in them that they're not going to go out and blow the money. Well, maybe we need to amend the documents and make kids the co-trustees if something happened to mom and dad. Maybe your net worth has exceeded the federal exemption thresholds for estate tax purposes. The federal thresholds for estate tax purposes currently, or I should say in 2026, will be $15 million per person. So if you're an individual and your net worth is above 15 million, there would be an estate tax on the delta. If you're married and your net worth was above 30, there would be an estate tax on the delta. This is all at the federal level. If you're below those thresholds, no estate tax. But that would be an instance in which you would want to amend your documents. So life-changing events dictate when you should be amending your documents. You'll know, and when in doubt, give your attorney a shout.
Living will and how is it different from a healthcare proxy?
Thank you so much, Charlie. And as mentioned earlier, we had two slides on the healthcare proxy, healthcare directive, living will. And all of those terms are all synonymous. Typically, all of these kind of provisions are all in one document. In ours, it's the healthcare directive. A living will is not the will. A living will is your healthcare directive. And so in our firm, we don't like using the term living will because it just causes and creates a lot of confusion. And the healthcare proxy, the word proxy is just who is going to make decisions for me on my behalf for my healthcare, right? So it's your healthcare agent. So in our healthcare directive, not only are you going to select your healthcare agents, quote unquote, the healthcare proxy, but you're going to also have your healthcare directive in there directing us to what you'd want for life support, organ donation, cremation versus burial. And then there should be a HIPAA release in these documents giving power to the medical facilities, the doctors, the hospitals to be able to communicate with the people you've nominated without them violating any HIPAA rules as well.
Okay, we have a couple more questions and then we'll be able to close out here. Where should I store my estate planning documents?
Beautiful. In our perfect technological world we have today, I would absolutely say scan your docs in, your most current docs in, and find some secure online storage that you like and save them up in the cloud somewhere. And I would give key players in your family access to that file. So think about your spouse, think about your adult children, your trustees, your guardians. They all work in that one file. I wouldn't give them all their own digital copy because you're going to maintain your originals with the wet signatures on them in hard format. And then whenever you update that, you're going to get new scans. And if you give everyone scans, you're going to have to constantly be updating the 10, 4, 5, 10 people that you've shared your scans with. Whereas if you control it out of one bucket, some online depository, think of Box or Dropbox or Google Docs, whatever it is, some online storage where everyone has access to one master file. And then your hard copies, I keep my hard copies at home in my home office. I tell our clients to keep them in their master closet high up on a shelf so that if they have guests over, they have kids, their kids aren't, flailing through these documents. You just want to keep them safe. But remember, your digital files are there as well up in the cloud, and you just want to keep them up to date. Another very important thing in our world today, we're all digital, we all gone paperless. Our bank statements, we're all paperless with our bank statements. So we're not getting those statements in the mail anymore, and our families don't know where we bank. So my firm provides our clients with a legend as to where their assets are. Now, this is something the client maintains. They don't share with us. It's broken down by asset class, checking, savings, trading, retirement, life insurance, real estate. List out, either the account number or last four, institution, maybe a phone number. We don't care about values. We just want to know, where are you banking? What's the account number? So that way, should something happen to you, your family knows, your trustees know which banks to start to communicate with. But remember, that list does not supersede the fact that you have to transfer your accounts into the trust. That's a must, and there's a strategic way on that, how that needs to happen, and your attorney should absolutely be providing you that guidance. And if they don't, you want to find somebody who does. So make sure that when you are interviewing your attorneys, make sure they give you the full service when it comes to this, not just drafting of the documents.
Thank you. Do beneficiary designations override my will?
Very, very good question. And I'm going to change this question because I think it should be more so along the lines of, do beneficiary designations override my trust distribution? Because remember, a will does not avoid probate, number one. So we never even want to question what a will does when it distributes our assets, because if you're thinking about a will and distribution, you're going through probate, and that's not what we want to do. So we want to have the trust in place. Now, our trust says everything is supposed to go equally to my kids. Let's just say I have the two children, everything's supposed to go equally to my children. Let's say hypothetically, on one of my life insurance policies, I had purchased it before I had my second child. And so on that life insurance policy, my primary beneficiary is my wife, and my contingent beneficiary is child one, the older child. And I never updated it. And God forbid I pass, even though my trust says everything goes equally, because the beneficiary designation on the trust states that that life insurance policy, if my wife isn't there, goes to what child one is going to inherit that entire policy. So yes, beneficiary designations are very tricky, and you need to walk through it with a fine-tuned comb, and we have a very strategic way in the way it needs to happen. When it comes to life insurance, your primary beneficiary, if you're married, should be your spouse, and your contingent beneficiary should be your revocable trust. And if you're not married, your primary beneficiary should be your revocable trust. This way, should something happen to you, the assets go into the trust, and now the trust terms dictate what happens. We don't have to worry about the beneficiary designations on the life insurance policy, because the designation there was saying the trust gets the money. Now, the trust has its own legal provisions, the contractual obligations on how these assets need to be distributed. So the trust terms will dictate what happens. We do have other assets that have beneficiary designations. I'll give you an example. Retirement accounts do. Now, retirement accounts are not probate triggering assets. They don't go through probate. Think of 401k. The 401k designation is an IRS code, excuse me. And the IRS says, look, you're taking this money out of your taxable income, putting into this account. IRS, am a partner on that account with you now, because some of that money is mine. The tax money on that's mine. You haven't paid it. When you pull the money out, you're going to pay me my portion. Now, they don't want that money. The IRS does not want that money to go to probate. So they've carved that out. They've protected it from probate. So your beneficiary designations there are controlled by people. If you're married spouse, your contingent beneficiary should be your children. And then people have the ability to open up what's called inherited IRAs to transfer the money from your retirement account to theirs when you pass, with no negative tax ramifications. We do not want the trust to be a beneficiary on retirement accounts, because the trust does not have the ability to open up an inherited IRA, which means the trust would then be forced to take the entire distribution out of your retirement account in the year you pass, and that entire amount will be seen on your income tax return and taxed at the tax bracket, most likely at the highest tax bracket. So in order to save money, it goes to people, it goes into their inherited IRAs. There are also beneficiary designations on our simple checking and savings and trading accounts. Now, remember, what are probate triggering assets? Probate triggering assets are checking, savings, trading accounts, and real estate. Your checking, savings, trading accounts, and real estate by title should change into the name of your trust, which means that we do not care 1% about the beneficiary designations on those accounts anymore, because that money does not go according to those beneficiary designations. It's actually going to go according to the terms of the trust, because the trust owns that account. Some people think that we'll leave the accounts in our names as individuals, but make our trust the beneficiary of our checking, savings, and taxable trading accounts. Now, that's a bad decision, because those accounts are probate triggering assets, and these beneficiary designations don't avoid probate. So just because we named our trust on our checking, savings, or taxable trading account as a beneficiary, we in our minds today feel comfy that, hey, we're going to avoid probate, but in reality, you're not. Now, when you're gone, your family's going to deal with it. So we do not want to rely on those beneficiary designations on checking, savings, and trading accounts. We want to make sure that they're actually physically transferred into our trust.
Thank you. Final question, which you spoke about, digital assets. What are digital assets, and should I include them in my estate plan?
Perfect. Yeah, digital assets, newest type of asset that we all have, and even in the last like 5 to 7 years, it's kind of bifurcated a little bit. So, digital assets, number one, are your passwords, your login information, your credentials to the digital world. Think of your YouTube account, your Instagram account, your Twitter or your X account, Facebook, LinkedIn, whatever it is. Those are digital assets. And then you also have other digital assets like maybe Bitcoin, etc. Your digital assets like your passwords, etc. Well, when you set up a Instagram account or any other vendor third-party account, you're signing up with their website and their terms and services agreements. So they usually dictate what happens to those assets when people pass. And more often than not, over the last 10 years, new laws like RUFADA have come out, which dictate that if you have a trust and you have the provisions in your trust should be able to be utilized with the Facebooks of the world to give power to your trustee to be able to close or get power over the account or close the accounts down. So that handles that. When it comes to the Bitcoin of the world, there's two types of those types of digital assets. One is what we call centralized, and the other is decentralized. Decentralized is the type of Bitcoin mining that people do that is a key. It's like a web key, and it doesn't sit with a bank, and it's on a piece of paper that someone has saved. That is decentralized. There's no real governance of that. That does not go into your trust because it can't, because it's just a code. There's no bank account or entity that we can communicate with. So you just need to do what you need to do on your end to protect your key in order to make sure that the assets, the equity of that key goes to the people you want. And again, that's just a physical thing. When it comes to the centralized type Bitcoin, think of Coinbase or other wirehouses that offer Bitcoin as equity securities. You will have an account at those institutions, and those institutions should allow you to transfer the account into the name of your trust, just like your checking or savings accounts.
That's a lot of information. I just didn't take into consideration how technology has really increased our assets across the board.
And it's only going to get more complex as time goes on. Think of all the AI that's going out and everything else that's happening around us. As our world expands, we're going to have to expand our thinking and logic when it comes to your estate planning as well.
Right. Well, thank you so much, Kern, for an informative estate planning webinar. We extend our sincere gratitude to you for presenting such a valuable and insightful estate planning webinar for us. Your expertise and thoughtful guidance will provide our legal plan members with a clear understanding of how to protect their assets and plan for the future. For those who have questions or would like personalized assistance with estate planning, please contact LegalEASE. Our team is ready to help you navigate your legal needs with confidence and care. Thank you, Kern.
Thank you so much, Charlie, and thank you to the entire Legal Access team, and thank you to everyone joining us today. God bless.